Hello students, today we'll study about the Memorandum of Association, which is one of the most important documents which must be filed with the registrar in order to secure the company's registration. Now, a memorandum has been variously defined as the unalterable charter of the company. It has been also called the constitution of the company in its relationship to the outside world. It is one of the documents which has to be filed with the registrar of companies at the time of incorporation of a company. Thus, it is very important as it contains the fundamental conditions upon which alone the company is allowed to be incorporated. According to Palmer, the Memorandum of Association contains the objects for which the company is formed and therefore identifies the possible scope of its operations beyond which its actions cannot go. If we talk about the purpose of memorandum, it serves two important purposes. Memorandum enables the intending shareholder to know the field of activity or to what purposes money is going to be used by the company and what risk he is taking in making the investment. Similarly, anyone who is dealing with the company, for example, the supplier of goods or money, will know whether the transaction he intends to make with the company is within the objects of the company and not ultra vires its objects. Ultra vires means beyond the powers. Now let's discuss the main clauses of Memorandum of Association. We have 6 clauses of Memorandum of Association: the name clause, registered office clause, object clause, liability clause, capital clause, and subscription clause. Name clause contains the name of the company with limited or private limited as the last words in the name depending on the type of the company. However, Section 8 companies may drop the words limited or private limited from their names. The second clause is known as the registered office clause or the domicile clause. It states the name of the state in which the registered office of the company is to be situated. Then we have the object clause, which must state only the object for which the company is incorporated along with matters considered necessary for its furtherance. The fourth clause is the liability clause, which states the manner in which the liability of its members is to be limited, that is, either by shares or by guarantee. The capital clause contains the amount of authorized share capital divided into share of fixed amounts and the number of shares which the subscribers to the memorandum have agreed to take, indicated opposite their names, which shall not be less than 1 share. A company not having share capital need not have this clause. Then we have association clause. This clause states the desire of the subscribers to be formed into a company. The memorandum shall conclude with the association clause. Now let's discuss in detail the contents of Memorandum of Association. So the first clause is the name clause. A company being a distinct legal entity must have a name of its own in order to establish its separate identity. Right? However, the general rule is that a company can be registered with any name it likes, subject to the following restrictions. Now, the last words of the company name must end with the words limited or private limited or one person company, that is OPC, as the case may be, except for Section 8 companies. No company can be registered with a name which in the opinion of the central government is undesirable. If a name is identical with or it closely resembles the name of an existing company or LLP or is not indicative of the object of the company, it must be deemed to be undesirable by the central government. The name of the company must also be indicative of its object, right? The name adopted by the company should also not violate the provisions of the Emblems and Name Prevention of Improper Use Act 1950. This act, for example, prohibits the use of the official seal and emblems of the central and state governments, United Nations, World Health Organization, Indian national flag, etc. Right? So the name should also not connote government participation or patronage unless circumstances justify the usage of such words. For example, the company should not use the name national, union, central, president, Rashtrapati, nation, municipal. Like all these words should be avoided. Then the name should not include any word or words which are offensive to any section of the society. No company can be incorporated using the name of an enemy country. Enemy country means so declared by the government of India from time to time. Then we have is the registered office clause. This is also known as situation clause or the domicile clause or registered office clause. So as per section 4 subsection 1b, this clause shall contain the name of the state in which the company's registered office is situated. The registered office clause is important for two reasons. It determines the domicile of the company, right? And secondly, it is at the registered office where the company's statutory books are normally kept and to which notices and other communication can be sent. Further, if we talk about section 12 provides that a company must have its registered office within 30 days of its incorporation. This section further provides that the company shall furnish to the registrar verification of its registered office within 30 days of its incorporation. For this, the company shall file form number INC 22 with the registrar along with the fees and attach to it documents such as the title deed of the premises in the name of the company, notarized copy of the lease agreement in the name of the company, or electricity or water bills in the name of the company. The next most important clause in the Memorandum of Association of a company is the object clause. It is the object clause which lays down the objects or whys of the company. A company cannot do anything beyond or outside its objects, and any act that is done beyond them will be ultra vires and void. Now, why object clause is so important? The object clause should be drafted with great detail and care as it serves three important purposes. Firstly, it offers protection to the shareholders by ensuring that funds raised for one undertaking are not going to be risked in other. Secondly, it provides protection to the creditors. Thirdly, it also serves public interest. The object clause has the effect of confirming corporate activities within a defined field. So a company can choose any object subject to the following restrictions, following conditions. Object must not be illegal. That is, if a company cannot be formed to carry on the business of smuggling, that is illegal. So a company having the objective of doing the business of smuggling, that means it is having ultra vires objects. It must not be immoral or against public policy. That is, if a company is doing trading with an enemy company, that is not allowed. It should not be against the Companies Act 2013 provisions. The objects must be expressed clearly and definitely. That means the object clause should not contain any ambiguous statements. For example, our object is to carry on any business as it may deem profitable. This is an ambiguous statement or a statement with confusion. So no ambiguous statement is allowed to be written in the object clause. Next we have is the liability clause. Now liability clause states the nature of liability of the members. Section 4, subsection 1, subsection D provides that in case of a company with limited liability, it must state whether the liability of its members is limited by shares or it is limited by guarantee. This means that in the case of a company limited by shares, the liability of its members is limited to the amount unpaid, if any, on the shares held by them. A member can be called upon at any time to pay to the company the amount that is unpaid on the shares. In case of a company that is limited by guarantee, the liability of the member is limited to the amount that each has undertaken to contribute in the event of its being wound up while he is a member or within 1 year after he ceases to be a member for payments of debts and liabilities of the company. Next we have is the capital clause. The fifth clause of the memorandum is the capital clause. This clause states the amount of share capital with which the company is registered, along with the number of shares into which the capital is divided, and the amount or denomination of each share. So section 4, subsection 1, subsection E provides that in case of a company having share capital, the memorandum must state the amount of share capital with which the company is to be registered and its division into shares of its fixed denominations, as well as the number of shares which the subscribers to the memorandum have agreed to subscribe to, which will not be less than 1. It should also mention the number of shares each subscriber intends to take indicated opposite his name. Also, in the case of the OPC, who in the event of death of the subscriber shall become the member of the company. Now the last clause is the association clause. According to section 3, the memorandum of every company must end with an association or subscription clause or a declaration of association which reads something like this: we, the several persons whose names and addresses and occupation are subscribed, are desirous of being formed into a company in pursuance of this memorandum of association, and we respectively agree to take the number of shares in the capital of the company set opposite our respective names. So according to section 3, a memorandum must be signed by at least 7 persons in the case of a public company and by 2 persons in case of a private company and 1 person in case of a OPC, along with the name of his nominee. Now let's start with the second most important document, Articles of Association. Now, Articles of Association are just like the partnership deed in a partnership. They set out provisions for matters like share capital and variation of rights, alterations of share capital, making of calls, lien on shares, forfeiture of shares, surrender of shares, the qualifications of directors, their appointment, remuneration and powers, duties of auditors, procedure for transfer and transmission of shares, buyback, etc. So these are the contents of the Articles of Association. Articles of Association is the document which lists the regulations which govern the running of a company, setting out the rights and duties of the directors, and the stakeholders individually and in meeting. The Articles of Association is a document that regulates the rights of members of the company among themselves and the manner in which the business of the company shall be conducted. So let's discuss the importance of the Articles of Association for the company. The legal effect of the Articles of Association is that it regulates the behavior between the company and the members. It regulates the behavior between member and member, and it also regulates the behavior between the company and outsiders. These are the contents that are mentioned in the Articles of Association. The Articles of Association shall contain the following matters. It can be related to share capital and variation of rights. It can be about the share lien, calls on share, transfer of shares, transmission of shares, forfeiture of shares, alteration of capital, capitalization of profit, buyback of shares, procedure of general meetings, adjournment of meeting, voting rights, proxy, board of directors, proceedings of the board, the common seal, dividends and reserve, accounts, winding up, indemnity, etc. So all these are the contents in the Articles of Association which the company has to mention. Now, the Companies Act 2013 specifies the different forms of AOA, that is the Articles of Association. The company can adopt the various tables as their AOA. Table F is about the Articles of Association of companies limited by shares. Table G gives the Articles of Association of companies limited by guarantee and having share capital. Table H gives us the Articles of Association of companies limited by guarantee and not having share capital. Table I gives the Articles of Association of unlimited companies and having share capital. Table J gives us the Articles of Association of unlimited companies and not having share capital. So, the company can adopt one of the following tables as their AOA. Now, if we talk about the relationship between the memorandum and the Articles of Association, the relationship between memorandum and articles has been aptly summed up by Lord Keynes in Ashbury Railway Carriage and Iron Company Limited versus Richer 1875. The articles of a company are subordinate to and controlled by the Memorandum of Association, which is the dominant instrument and contains the general constitution of the company. So we can say that AOA is subordinate to the MOA. In other words, the articles cannot contain any provision which is against the Companies Act or the memorandum or the law of land or public policy. So memorandum and articles are to be read together, and ambiguity or uncertainty in the one may be removed by reference to the other. If there is any conflict between the two documents, MOA and AOA, then the provisions of the MOA will prevail. The memorandum can be altered only under certain circumstances provided by the Act, but the articles are only internal regulations over which the members of the company may have full control and may alter them according to what they think fit. The acts done by a company beyond the scope of the MOA are ultra vires and thus void. Ultra vires, I told you before, it means beyond the powers, and thus it will be considered as the void agreements. They cannot be ratified even by the unanimous consent of all the shareholders. But acts beyond the articles can be ratified by shareholders provided the relevant provisions are not beyond the memorandum. So let's discuss the difference between Memorandum of Association and Articles of Association. Memorandum of Association is the charter, or we can say it is the constitution of the company. It indicates the nature of business and its capital. It also defines the company's relationship with the outside world, whereas AOA are the internal regulations, the regulations for the internal management of the company, and they are subsidiary to the memorandum. Memorandum of Association defines the scope of the activities of the company, right? But articles are the rules for carrying out the objects of the company as set out in the Memorandum of Association. So we can discuss the difference in the tabular form. The first difference is about the objectives. MOA defines and delimits the objectives of the company. So it gives the scope of the company, scope beyond which the company cannot go. Whereas the Articles of Association lays down the rules and regulations for the internal management of the company. We have discussed earlier that memorandum is subordinate to the Companies Act 2013, but it lays down the parameters for the articles. Articles are subordinate to MOA and the Companies Act 2013. If we talk about the further distinction of alteration, Memorandum of Association can be altered only under certain circumstances, as provided by the Act, and in most cases, we have to take the permission of the regional director or the tribunal. Whereas Articles of Association can be altered by passing a special resolution because these are related to the internal rules and regulations of the management of the company. Memorandum defines the relationship of the company with the outside world, whereas articles, it defines the relationship between the company and its members. Acts that are done by the company which are beyond the scope of the MOA, they are termed as ultra vires and void. Thus, we can say that these cannot be ratified even by the unanimous consent of all the shareholders. Whereas if we talk about the acts, ultra vires, the articles, these can be ratified by just passing a special resolution of the shareholders.